A cross-border worker or a frontier worker is a person who lives in one country and works in another country. Cross-border work differs from migration, as the workers still maintain their primary residence by commuting to work in a neighboring country or on a different side of their national border on a regular basis. Cross-border working can be affected by many factors, one of which is complementary socio-economic conditions. This occurs when there are wage differentials and employment opportunities that match the skills of the workers, which are only available across the border. Other factors might relate to the easy access or practical transport links to other countries and affordable housing options. However, this phenomenon leads to several labor issues, including, but not limited to, differences in social security, pension, and taxation. For example, several tax authorities are faced with cross-border working issues to implement rules regarding their taxation. This might be connected to the differences in taxation systems between the country of employment and the country of residence. Cross-border working happens in a lot of countries, namely Canada, Mexico, the United States, Luxembourg, Singapore, Malaysia, etc. Each country usually adopts their own regulations regarding this matter. For instance, Germany adopted a regulation where the employees, including any cross-border workers in their country, are generally subject to their social security regulations.
As what we've explained before about what a commuting employee, or also called as cross-border worker, is, we could define that it is when a person who works in a country but lives in another country and they're moving and commuting every day, occasionally to work. It is clear that we're talking here is not about the commuting employee that is moved back and forth within cities, but it is between countries. Workers who are crossing borders to work, of course, should pass some checks such as police checks or travel documents. Somehow it's complicated, but back again, it is an obligations because they're moving to another country, which has different rules, different regulations with their origin countries. This is kind of employment usually happens with a country with land border, for example, between Indonesia, Malaysia, Vietnam, Indonesia, and Singapore, between European countries, or what we call also as European Union, or cross-border worker in USA and Canada. But that leads us to some questions. How about the protections of cross-border worker? Which country should provide protections such as social securities, like healthcare, family benefits, retirement, job protections, etc.? Is it the country of origin or the country of destinations? To answer that questions, we're going to take example of cross-border worker protections in European Union countries. European Union is an economic and political union of countries, consists of 27 countries, such as Austria, Belgium, Bulgaria, Denmark, France, Germany, Luxembourg, Netherlands, Spain, and many more. It operates an internal single market which allows free movement of goods and services, including people between member states, or what we call as free movement of person. Free movement of person means that EU or European Union citizens can move freely between member states, either to live, study, work, or maybe retire in another country. The laws that applied for the workers are from both countries, where the laws from the country from origin will covering the property taxes and most taxes with residence formality. Meanwhile, the destinations or working countries, it will covers the employment and income taxes and also most of the social security rights. In social security, first, healthcare. A cross-border commuter or cross-border workers are entitled to a medical treatment in both countries, and the family members are also entitled to a medical treatment if they lived in European Union countries. Next, family benefit. In European Union countries, the country responsible for workers in social securities, including family benefits such as child benefits, child raising loans, and many more. Family benefits differ greatly within Europe because European Union countries are free to establish their own rules, entitlement to benefits and services. Social securities is retirement or old age pension. So if you work in several European Union countries, for example, I work in Denmark, then I moved to Germany, then I moved to Luxembourg, then I moved to another country, and so on, I might have a pension accumulated from each of it. Lastly, regarding the unemployment, if we are a cross-border workers and lose our job, either it is employed or self-employed, we could only claim the unemployment benefits in the country where we live. And these are the example or the explanations of the social securities that are provided by the European Union countries. And we could see that the government is really neat and it's really comprehensive by making regulations about the social securities. But we will see how about Indonesia. So we're going to see the explanations after this.
Next example is crossing border between USA, Canada, and Mexico. According to the 2011 National Household Survey, there are approximately 15.4 million Canadians that commute to work, while 1.1 million work at home most of the time. And there is 119 border crossings between US and Canada, and while much of the traffic that occur may be due to those travelers that are headed to their daily jobs. They are professionals like nurses, auto workers, and executives. It's the same with thousands of the Mexicans who every morning line up at the US-Mexico border to work. So this is the situation in San Isidro border in Mexico border that is the busiest border crossing in the world. So the first question, what about the legal status of the commuter employees? So to answer that question, first of all, in most cases, an individual who holds green card status in the US must reside there permanently or they will risk losing their status. However, people who have been granted permanent resident status may live in Canada or Mexico even without maintaining a home in the US if they commute regularly for employment in the US. This administrative grant of commuter status is only available to lawful permanent resident or LPR living in Canada and Mexico. To apply that commuter status, an individual must inform CBP or cross-border protection at a border crossing they are intended to, and they will be required to complete paperwork every 6 months and will need to present evidence of their regular employment in the US, and CBP will notate the green card to reflect alien commuter status. How can we obtain the commuter status? To be an eligible commuter status, an applicant must meet these following requirements. First, establish LPR status. Second, establish he or she lives in Canada or Mexico. And the last one is establish employment in the US within the 6 months before filling the application. But a commuter who has been out of regular employment in the US for continuous period of 6 months lose LPR status. However, there is an exception applies when the employment was interrupted for reasons beyond the presumption is where you will have to pay taxes during your stay abroad. If you live and work outside of Canada for more than 183 days for a year, the CRA or Canada Revenue Agency will consider you as a non-resident of Canada for tax purposes. According to CRA, non-residents can only be taxed by Canada on income that received from Canadian sources. That's all for the cross-border activity in US, Mexico, and Canada.
In my part this time, I will discuss one of the problems that often arise in cases of cross-border workers, namely the problem of Social Security. Social Security refers to the protection that a society offers to individuals and households in order to secure access to health care and financial security, especially in circumstances of old age, unemployment, sickness, invalidity, job injury, maternity, or loss of a breadwinner. The right to Social Security is currently established in Indonesia's constitution. It constitutes the social compact between the state and society. For Indonesian workers, Social Security (BPJS) is mandatory for any company. If you own a company, you must register all of your employees to this kind of BPJS. Otherwise, if you work in a company in Indonesia, your company must provide you with the service of obtaining Social Security card. However, if you are a freelancer and you would like to have one, you can also register as an independent Social Security BPJS member. For Indonesian workers that are posting in other countries, there are also a type of social security provided by the government. As an example, in a program called TKI Insurance Program. In this program, basic needs such as insurance, legal assistance, labor attaché, etc. is provided. This program has a legal basis such as regulated from Law Number 13, year 2003 on employment, Law Number 39, year 2004 on placement and protection of Indonesian workers abroad, Law Number 6, year 2012 on ratification of International Convention on the protection of the rights of all migrant workers and their families. However, in the case of cross-border workers in Indonesia, evidently, the law protecting cross-border commuters is still vigorously enforced. This generates legal confusion for cross-border commuters and impedes the achievement of SDG's goal of full and productive employment. As a result, we have a lot to learn from countries that have successfully implemented a system of cross-border worker protection as a model for implementing the system in our own country. From here, we can learn that the application of Social Security should be based on an agreement with which country that has a lot of cross-border workers who are from Indonesia to make regulations regarding cross-border workers. For example, between Indonesia with Malaysia or Singapore, which has a lot of workers commuting.
Everyone, my name is Sharon Karli. Today, I will explain what differentiates cross-border commuting workers from regular migrant workers. According to the European Union law, when a worker works in one EU country and returns to their house in another EU country daily or at least once a week, it will be considered as cross-border commuter. Whereas, under International Labour Organization, migrant workers are defined as a person who migrates from one country to another or who has migrated from one country to another with a view to being employed other than on his own account, and includes any person regularly admitted as a migrant for employment. Basically, what differentiates cross-border commuter from migrant workers is that the residences of cross-border commuter are still in the country of residence, not in the destination country. However, for migrant workers, the residences also move to the destination country. Cross-border commuters are already governed in other countries and are widely accessible. For instance, the European Union in its official website provides information regarding the health insurance coverage. While law governing the migrant workers is accessible and quite widely known, for example, Law Number 39, year 2004 concerning the placement and protection of Indonesian workers. Unfortunately, in Indonesia, law protecting the cross-border commuter is still strictly accessible. This creates a legal uncertainty for cross-border commuter and hinder the fulfillment of the full and productive employment under goal number 8 of the SDGs or Sustainable Development Goals.